you think that in the contest phase there must be a uniform standard for counting the ballots?
I do, Your Honor. I think there must be a uniform standard. I think there is a uniform standard. The question is whether that standard is too general or not. The standard is whether or not the intent of the voter is reflected by the ballot. That is the uniform standard throughout
very
the
general.
state of Florida.
It runs throughout the law. Even a dog knows the difference in being stumbled over and being kicked. We know that. Now, in this case, what we're concerned with is an intent that focuses on this little piece of paper called a ballot. And you would say that from the standpoint of the Equal Protection Clause, could each county give their own interpretation to what intent means so long as they are in good faith and with some reasonable basis finding intent?
I think...
Could that vary from county to county?
I think it can vary from individual to individual. I think that just as these findings...
So that even in one county can vary from table to table? I'm counting these ballots.
I think on the margin, Your Honor, whenever you're interpreting intent, whether it is in the criminal law and administrative practice, whether it is in local government, whenever somebody is coming
but
to
here
government...
you have something objective. You're not just reading a person's mind. You're looking at a piece of paper. And the Supreme Courts in the state of South Dakota and in the other case have told us that you will count this if it's hanging by two corners or one corner. This is susceptible of a uniform standard. And yet you say it can vary from table to table within the same county.
With respect, it is susceptible of a more specific standard. And some states, like Texas, have given a statutory definition. Although even in Texas, there is a catch-all that says anything else that clearly specifies the intent of the voter. So even where states have approached this in an attempt to give specificity, they have ended up with a catch-all provision that says, look at the intent of the voter.
But they have ended up with the catch-all provision because, I assume, there may be cases in which the general rule would otherwise operate, in which there is an affirmative counter-indication to what the general rule would provide. But I think what's bothering Justice Kennedy, and it's bothering a lot of us here, is we seem to have a situation here in which there is a subcategory of ballots in which we're assuming, for the sake of argument, since we know no better, that there is no genuinely subjective indication beyond what can be viewed as either a dimple or a hanging chad, and there is a general rule being applied in a given county that an objective intent or an intent on an objective standard will be inferred. And that objective rule varies, we're told, from county to county. Why shouldn't there be one objective rule for all counties, and if there isn't, why isn't it an equal protection violation?
Let me answer both questions. First, I don't think there is a series of objective interpretations, objective criteria that vary county by county.
All right, but on the assumption that there may be, if we were fashioning a response to the equal protection claim, and we assume as a fact that there may be variations, wouldn't those variations as from county to county on objective standards be an equal protection violation?
I don't think so, Your Honor, because I think there are a lot of times in the law in which there can be those variations from jury to jury, from public
yes,
officials.
But in jury-to-jury cases, we assume that there is not an overall objective standard that answers all questions definitively. We are assuming that there is detail that cannot be captured by an objective rule. The assumption of this question, and I think it's behind what's bothering Justice Kennedy, Justice Breyer, me, and others, is we're assuming there's a category in which there just is there is no subjective appeal. All we have are certain physical characteristics. Those physical characteristics, we are told, are being treated differently from county to county. In that case, where there is no subjective counter-indication, isn't it a denial of equal protection to allow that variation?
I don't think so, Your Honor, because And maybe I am quarreling with the premise that says there are these objective criteria. Maybe if you had specific objective criteria in one county that says we're going to count indented ballots and another county that said we're only going to count the ballot if it's punched through, if you knew you had those two objective standards and they were different, then you might have an equal protection problem.
All right, we're going to assume that we do have that. We can't send this thing back for more fact-finding. If we respond to this issue and we believe that the issue is at least sufficiently raised to require a response, we've got to make the assumption, I think, at this stage, that there may be such variation, and I think we would have a responsibility to tell the Florida courts what to do about it. On that assumption, what would you tell them to do about it?
Well, I think that's a very hard question.
You tell them to count every vote. You'd tell them to count every vote, Mr.
I would tell them to count every vote. I think
let me answer that question, Mr. Boies.
I think I would say that if you're looking for a standard, and I say that not because of the particular aspects of this election, the Texas standard, if you wanted to specify something that was specific, gives you a pretty good standard.
The only thing I'd like this question, Mr. Boies, does not the procedure that is in place there contemplates that the uniformity will be achieved by having the final results all reviewed by the same judge?
Yes, that's what I was going to say, Your Honor. That what you have here is you have a series of decisions that people get a right to object to. This is all going through a process. The people are there. They submit written objections. And then that's going to be reviewed by a court.